In this video, I'll explain how to move your foreign company to Florida and I'm going to walk you through the legal roadmap step by step. We will cover domestication and setting up a U.S. subsidiary. And by the end of this video, you will understand exactly which path is right for your business, what paperwork you need, and how to avoid the costly mistakes I see foreign entrepreneurs make every single week. I'm Santiago, Cueto, board certified international business law expert and best-selling author based right here in Miami, Florida. I've helped hundreds of business owners from Latin America, Europe, and beyond plant their flag right here in the U.S. market. So trust me when I say this process is not as complicated as most people think. But here is what most people get wrong. They jump straight into paperwork before they even understand their options. That leads to the wrong structure, unexpected tax exposure, and sometimes having to start over from scratch. So let us do this in the right way. First, let me paint a picture for you. You have a company operating in another country, business is going well. Now you want to access the U.S. market. Maybe you want U.S. banking. Maybe you want to contract with American clients. Maybe you want to physically relocate your operations. Florida is calling your name, I get it. It's the #1 destination for international entrepreneurs in the United States right now. The tax advantages alone make it hard to ignore. No state income tax, a business-friendly regulatory environment, and a geographic location that puts you right at the crossroads of the Americas. But wanting to be in Florida and legally establishing your business in Florida are two different things. You cannot just show up and start operating. Well, technically you could, but you would be exposing yourself to serious legal and financial risk. So let us talk about the two main paths available to you. The first path is called domestication. Think of it like this. Your company currently has a home. That home is in another country. Domestication is a legal process of moving that home to Florida. Your company does not die and get reborn. It continues to exist. It keeps its history, its contracts, and its obligations. But its legal domicile shifts to the state of Florida. Now here's the catch. Florida does allow domestication, but only for certain jurisdictions. The foreign country where your company is formed must have a comparable domestication statute. If it does not, this path is off the table. Many Latin American countries, for example, do not have equivalent laws. That does not mean you're stuck. It just means we need to look at a different route, which I'll cover in a moment. For those who do qualify, the process works like this. You file what is called Articles of Domestication with the Florida Division of Corporations. Along with that filing, you submit your existing governing documents translated and adopted to comply with Florida law. You'll also need a certificate of good standing from your home jurisdiction. This proves your company is in good standing where it currently exists. Once Florida approves the filing, your company becomes a Florida entity. Same company, same EIN if you already have one, same contracts, but now governed by Florida law. The beauty of domestication is continuity. You do not have to renegotiate contracts. You don't have to transfer assets to a new entity. Everything carries over. But I want to be very clear about something. Just because the corporate structure transfers does not mean your tax situation transfers neatly. You absolutely need to work with a cross-border tax advisor before you file anything. I have seen the business owners domesticate their company and then get blindsided by unexpected tax consequences in their home country. The corporate move might be clean. The tax picture might not be. Get professional guidance on both sides. Now, before we get into the second path, if you're finding this helpful, go ahead and hit that like button. It takes 2 seconds and it helps more international entrepreneurs find this information. And if you are serious about doing business in the U.S., subscribe to this channel. I put out new videos every single week covering exactly these kinds of topics. All right, the second path, and honestly, the more common one I see in my practice, is forming a U.S. subsidiary. This is where you keep your foreign company intact. It stays where it is. Nothing changes with that entity, but you create a brand new company in Florida that is owned by your foreign company. Think of it as your foreign company becoming the parent. The new Florida company becomes the child. The parent controls the child, but they are legally separate entities. This is a critical distinction. So why does this matter? Liability protection. If something goes wrong with the Florida operation, Creditors generally cannot reach back to the parent company overseas. That wall of separation is one of the biggest advantages of the subsidiary structure. All right, so how do you set this up? Step 1, you choose your entity type. Most foreign business owners forming a subsidiary in Florida will choose either a corporation or a limited liability company. Each has different tax implications. An LLC offers pass-through taxation by default. A corporation is taxed at the entity level. The right choice depends on your specific situation, your home country's tax treaty with the U.S., and your long-term goals. This is not a decision to make based on a Google search. Get proper advice. Step 2, you file your formation documents with the Florida Division of Corporations. For an LLC, that means Articles of Organization. For a corporation, Articles of Incorporation. You will need a registered agent with a physical address in Florida. You will also need to designate your officers or managers. In step 3, you obtain your EIN from the IRS. This is your company's tax identification number. Foreign-owned companies can obtain an EIN, but the process is slightly different than it is for domestic owners. In most cases, you will need to apply by phone or mail rather than online. And step 4, you open up a U.S. bank account. This is where many foreign entrepreneurs hit a wall. U.S. banks have strict compliance requirements, especially for foreign-owned entities. You will need your formation documents, your EIN, your operating agreement or bylaws, and often proof of your foreign company's existence. Some banks will also require you to appear in person. You need a plan for this. It takes longer than you expect. In step 5, you put the proper agreements in place between the parent and the subsidiary. This includes intercompany agreements, transfer pricing documentation, and sometimes licensing or service agreements. These documents matter because the IRS will scrutinize transactions between related entities. If your parent company in Colombia is providing services to your Florida subsidiary, that transaction needs to be documented at fair market value. Skipping this step is one of the most expensive mistakes I see. Now let me address a few things that apply no matter which path you choose. First, immigration. Forming a Florida company does not give you the right to live or work in the United States. Those are completely separate processes. I see this misconception all the time. Your company can exist in Florida. That does not mean you can. If you plan to relocate personally, you need to work with an immigration attorney in addition to a business attorney. And second, ongoing compliance. Florida requires an annual report for every registered entity. Miss that filing and your company gets administratively dissolved. It's a simple form and a small fee, but you need to stay on top of it. You'll also have federal tax obligations and potentially state-level obligations depending on your business activities. And third, consider your intellectual property. If your foreign company holds trademarks, patents, or proprietary technology, you need to think carefully about how those assets relate to your Florida entity. Licensing those assets properly between the parent and subsidiary can provide significant tax planning opportunities, but it needs to be done correctly from the start. And finally, do not underestimate the importance of your operating agreement or corporate bylaws. These are the internal rules that govern how your Florida company operates. For a subsidiary, they need to reflect the reality that a foreign entity is the owner. They should address decision-making authority, profit distribution, and what happens if the business relationship changes. A template from the internet won't cut it. So let us bring this all together. You have two main paths to establish your business in Florida. Domestication lets you move your existing company here while maintaining full continuity. A subsidiary allows you to create a new Florida entity owned by your foreign company while keeping both entities legally separate. Each path has distinct advantages. The right choice comes down to your jurisdiction, your tax situation, your liability concerns, and your long-term business strategy. Now, if you found this video valuable, do me a favor, hit that like button, subscribe to this channel so you never miss a new video. Share it with another business owner who's thinking about making the move to Florida. And if you have questions about your specific situation, drop them in the comments below. I'm Santiago Cueto, your Florida business attorney, and be sure to watch more of my videos right here.